Judicial activism is a judicial philosophy that allows judges to consider broader societal implications when making rulings, rather than just the applicable law. It's often contrasted with judicial restraint, which is when judges focus on precedent and are less likely to reinterpret the law. Here are some characteristics of judicial activism. 1. Judges use their own views. Judges make rulings based on their own views, rather than precedent. 2. Judges are more flexible. Judges are more willing to overturn legislative or executive actions. And 3. Judges use contemporary values. Judges use contemporary values when interpreting the Constitution. Judicial activism is a controversial political issue. Critics argue that judicial activism 1. Exceeds the proper exercise of judicial authority. 2. Is unjust to hold parties to a novel interpretation of the law. And 3. Risks upsetting the balance between the three branches of government. In India, judicial activism is the active interpretation of existing provisions to enhance the utility of legislation for social betterment. The Supreme Court of India has the authority to enact laws under Article 142 of the Indian Constitution. Some examples of judicial activism in India include 1. S.P. Gupta vs. Union of India. The Supreme Court observed that a passive or negative role by the judge may be disastrous from the point of view of social justice. 2. Air India vs. Nergesh Meerza. The court challenged the service regulations pertaining to the retirement of air hostesses as being violative of the right to equality. And 3. M. Siddiq, D. THRLRs vs. Mahant Suresh Das and Oz. The Supreme Court overturned the Allahabad High Court's ruling in accordance with Article 142 of the Indian Constitution.